was a young police officer, just off of probation, just transferred to Central Division. My partner and I received a call, shots fired, a robbery in progress up near Temple Street. And it happened that we had an individual in the back seat. I was in the back seat. An arrestee was to my right. My partner was driving, and he was under arrest for public intoxication. We shouldn't have rolled on that call, but being aggressive police officers, we did. And pretty soon, the call was followed up by another one, a robbery at a nearby gas station, same description, shots fired. We rolled into the area. We heard a broadcast that the suspect was headed in a certain direction of a street. And we were the first car in that area, and we were the first car to turn the corner into that street. And I noticed when we made the turn out the back window, there was a plainclothes police car behind us, occupied by what we knew as the detective headquarters team, 2 detectives in that car. We turned the corner. Within seconds, we were adjacent to an empty lot going uphill. And my partner stopped the car right in the middle of that lot and yelled at the suspect running up the street to halt. He turned and he pointed a weapon at us and he began firing. We ducked. There ended up with 3 bullet holes in our car. I told the arrestee to stay put. We were both on the floor. My partner threw me the mic. I put it on an officer needs help call. And an officer needs help call is the hottest call in the city. And then I told the drunk to stay put, and we deployed up both sides of the lot, making our way through the weeds. And we were able to spot the suspect lying in the grass, his hand about 3 inches from his weapon. For what reason, I don't know. We deployed in such a way as that we were able to take him in custody without harm to either the suspect or police officer. I mean, the suspect or either one of us. We used tactics and strategy, and we used the concept that the taking of a human life is last resort, as we were at that time somewhat taught in the police academy. We walked the suspect down to the hill to the point of where a tree was, where he fired at us. And we briefed the sergeant. Then we took him down further the hill. And by that time, the street was full of police cars because of the nature of the call. And as we reached the bottom of the hill, that detective headquarters car that was in back of us when we turned the corner just arrived. And the detective with the felt hat on and the cigar. And I want to preface this by the fact that a young police officer, especially at the age of 21, 22, at that point in his career, maybe one of the most coveted things he could achieve, he thinks, is to be a detective. And so the role modeling is important. The detective asked me what happened. I told him. Now, he's the last one to show up on the scene. And his reply to me was, "Kid, you should have blown the MF away." That was probably the most significant statement ever made to me in my 20-year police career with the Los Angeles Police Department, because I recognized that the influence of this man's statement could be a huge influence upon the molding of police officers and upon the culture of the police department. And as we know, those kinds of cultures exist in police organizations across the country. And we need to continue to correct those cultures and remove that kind of attitude and remove the militarization. So with that story, I move on to de-escalation, escalation training and use of force that includes both physical and the use of deadly weapons. And we taught that. Now I'll cut to my later time in the police department was a deputy chief of personnel and training. I I also sat as the chair of the use of force review board. We taught escalation, de-escalation of training. I personally taught use of force in the academy. I was probably the first deputy chief in the history of the department to teach that subject. They used to leave it to the sergeant level instructor in the academy. I teamed up with a member of the SWAT team because he was looked upon as a heroic character. And it re-emphasized to the officers being taught that even those in the elite units believed in the policies that we had. But along came a scandalous shooting in Los Angeles involving the killing of a Black woman by two police officers. One of the police officers was Black, one was white. Her name was Eula Love. She was throwing a butcher knife at the two officers and they fired and killed her. And the killing at the time was legal, but it wasn't really in conformance with what a good police policy should be. It was found in policy. There was dissension on the board, and there's also dissension with the Board of Police Commissioners. And the result is that we rewrote the policy, and this was in like 1978. And what is important is that we said as a preamble, the taking of a human life is precious, and the taking of a human life should only be at last resort. And that policy, saying at last resort, imposes many things in terms of police philosophy and in terms of police training. When you say at last resort, that means you have to use every measure available to you, every reasonable measure available to you to avoid taking a human life. And that means de-escalation, that means talking, that means tactics, strategy. It means everything that you can possibly do to reasonably avoid it. That policy and the training that followed it went into effect. And we saw reductions in police shootings in the Los Angeles Police Department at that time. There was only a year or so later that I retired. And it was in 1989, 9 years later, that the Supreme Court of the United States handed down the Graham versus Connor case, in which they talked about reasonableness and reasonableness only. And that began the era of what I call, oh, I shot because he went for his waistband. And the attitudes that came out of Graham versus O'Connor and the training that came out of Graham versus O'Connor, in my opinion, is the major contributor to the increase of what I call the waistband shootings across America. The training substantially changed. Even the training in the Los Angeles Police Department changed to accommodate that training. And it was a bad change. So we also saw the introduction of junk science from the Force Science Institute, the Zelinsky guy that would go around and train police departments. As a matter of fact, in my city, Long Beach, the chief of police loved it so much, he even invited Zelinsky's people to give a conference that he brought the press to, and leaders of community leaders in the Long Beach community. And Zelinsky's people would give him this junk science and convince him that if a person is shot in the back by a police officer, there are circumstances that justify that. and I know of none that are justified by that. But between Connor, the Graham versus Connor case, and the kind of junk science and training that came out of that case over the years, I believe that we saw the greatest increase in police shootings per capita across the nation. So, fortunately, in California, we got a couple of remedies, and one was AB 382, signed into law in August 2019, that brought about at least some level of uniform change and got rid of the reasonableness and introduced the taking of a life at a last resort concept. You can look up 392 and read the language, but that's what I feel it reintroduced. And I'll tell you that in my city, Long Beach, until the time of the passage of that law, the Long Beach Police Department had no preamble about the value of human life and the taking as a last resort. What their policy said was, if you face a situation that involves the threat of deadly force to yourself or another person, your duty is to fire your duty is to use your weapon. It doesn't talk about strategy, tactics, de-escalation, none of that. So even though the chief has made changes to his policy and changes to his training, and he takes credit for that change did not occur until Shirley Weber's AB 392 went into effect. And the result is that we are now seeing a reduction in police shootings. Long Beach averaged about 6 a year. They went 18 months the first time in the history I could find without a single shooting. And so this legislation is working. This legislation is science-based, and this legislation is going to continue to professionalize our police departments and protect our communities. Under the category of the militarization of police, I was in the Los Angeles Police Department when SWAT was first introduced. The Los Angeles Police Department was the first police department to ever have a SWAT team. It was based on a situation where officers were terribly outgunned. This was in the 60s. And officers came in and said, we need to do something. There was a young deputy chief in charge of patrol named Daryl Gates, who took it to the chief of police, Ed Davis, and introduced SWAT. And it was first finding and training people in the outlying divisions that could be brought together. It was ultimately brought under the roof of Metropolitan Division. Today they have 7 platoons. SWAT in the Los Angeles Police Department today spends 50% of their time training. They have the weapons, they have the armored vehicles, they have everything that's necessary to accomplish the job when the uniform officer, when the first responder on the street faces a situation that's beyond his capability. But SWAT in Los Angeles also has very stringent rules. They don't roll out of the barn with SWAT equipment unless the situation demands the use of their kind of strength. And they train 50% of the time under the policy that our mission, our primary mission, is to save lives, to save the life of the suspect, to save the lives of potential victims, and to protect the lives of police officers. The experience of the Los Angeles Police Department under this set of policies is that the last I checked, which was a couple of years ago, over 95% of their rollouts to highly, highly dangerous situations, over 95%, there has not been an injury, much less a death. So their policies should provide for a statewide or national model. But what has happened over the years as we have gone through this tough on crime era is that we had the 1033 program where the government handed out tanks and big weapons and flamethrowers and all of that to even the smallest police departments because every chief wanted one. But they never, I just ran out of time. So I better hurry.
No, you could go for another 10. Okay.
Okay.
All right.
They never trained. So many of these departments never trained and never used their equipment as a last resort kind of rollout, but they started using this equipment for every kind of possible excuse to use it. And the result is that we have seen this buildup of militarization. We saw Ferguson. We eventually saw Obama pull back on the program, and then we saw Trump reinstate the program. So we need to re-examine that as a community all across Los Angeles County to make sure that in the state, in fact, we have legislation that at the very least looks at the possibility of regional SWAT teams for small departments where they can afford a regional level training and response. We need legislation that at least establishes a basic standard like that used by the police department, at least until we get done and get guns off our streets in a more effective way. The next subject is the rise of police unions. When I was a captain, and I would have complaints from the community, I would investigate those complaints, especially complaints of use of force or bad language or bad treatment or racial slurs. I would be able to investigate those allegations. I would be able to make recommendations on how they should be adjudicated once I saw the full investigation. And I was in a position that I would be able to share that information with the community I work for, and the organizations I routinely exchange communications with. I had formed a police clergy council. I was in Southwest at the time. It was 95% African American community. The clergy was the best form of communication I had, as well as neighborhood groups. So many times I said it was unfounded, but I could explain why. Many times I said it was sustained. I could tell them why. And the ability to do that helped me as a command officer in a division establish a trusting relationship with a community that hated us when I first took that division over. And I was there for 5 years. And I believe that by the time I left, we were appreciated and respected. Unfortunately, in about 1978, the police unions started to feel their muscle, and they got the Police Bill of Rights passed. And many of the elements of the Police Bill of Rights were appropriate due process measures for the officers. But basically what it did, it shut down the ability for a command officer or a chief of police to explain how he dealt with community complaints, to explain individual cases. And in many cases, because of that legislation, many police departments stopped even explaining statistically how they handled complaints. The result over the intervening years have been that when we objected to this as police executives, I was the deputy chief at the time in personnel and training. At the time we objected, we said this kind of legislation is going to stop our ability to share this kind of information with our communities and gain better trust and explain the whys and wherefores of the investigations we conducted and the measures we took to adjudicate. And we had police executives across the board in favor of that. Today, or up until the passage of SB 1421, just a couple of years ago, last year, 18 months ago, I guess, time flies. When that legislation was being under examination in Sacramento, and I think it took 2 legislative sessions to get it done, we found police chiefs across the country, across the state, objecting. Because what had happened over the intervening years since 1978, they realized that their recommendations would no longer be subject to public scrutiny. And so there was a lot of hiding going on, and I believe that it has contributed to a lot of misconduct being covered up in police departments across the country. So now we got SB 1421. As a journalist in Long Beach, I found that the Long Beach Police Department wasn't being faithful to the legislation. They cheated. And so I brought 2 lawsuits against the Long Beach Police Department, suing them for not releasing public information under SB 1421. The first case, they settled. It cost the citizens $30,000 in attorney fees. The second case is still yet to be settled, and it's going to cost that much more. But we need to strengthen SB 1421, but it is providing a big jump in the release, especially of use of force and police shootings and misconduct, sexual misconduct by police officers, as well as dishonesty. In the dishonesty case that I am suing them for, we had a major conspiracy among 4 individuals in the jail system where they probably cheated the taxpayer out of at least $100,000 in false overtime claims. A civilian was fired. One police sergeant was fired, and 2 police sergeants were given suspensions. But they wouldn't release the dishonesty thing because, as required by SB 1421, because they classified it as conduct unbecoming rather than dishonesty. So these examples are examples that demonstrate we need to strengthen that legislation. And with that, and the recommendations I made earlier that go to the change I think we need to make, I will fold my presentation and return it to you, Ann, and I'm happy to remain and answer any questions.
Thank you. Thank you very much. Instead of doing questions right now, I would like to introduce our next speaker and then have questions after that. Is that okay, Steve?
Sure.
Okay. Okay, so our next speaker is Max Szabó. He's founder of the Szabó and Associates. It is a California media markets. He is a California media market specialist and licensed attorney. He led several successful reform efforts for District Attorney George Gascon and consulted on Gascon's LA County DA campaign. Max was also a co-architect of major criminal justice reform legislative initiatives such as AB 1076, an effort to leverage technology to automate record clearance at scale and provide expanded employment and housing opportunities for California residents. So please welcome Max.
Hi, everybody. Thanks, Anne. I appreciate you having me, and looking forward to being here today with you all. So Anne asked me to speak a little bit about Mr. Gascon's directives, and obviously, I think there's been Mr. Gascon's return to Los Angeles has not gone unnoticed, as you might say, with some of the directives that have been implemented. And there's certainly a lot of vitriol and a lot of misunderstanding and misinformation that's been flying in relation to these directives. So looking forward to answering any specific questions that you all may have about cases, to the extent that that I'm knowledgeable about them. But I kind of want to give you just a little brief overview. And I'm going to talk about the most controversial ones here with you all. So let's start with enhancements. So whenever somebody's charged with a crime, there's usually a spread. So, a robbery will come with 4, 5, or 6 years. Enhancements are additional time that can be added on to that base term, right? So if you commit a robbery with a gun, you can get either the low term, 4 years, 5 years, or 6 years, and then you can add on additional enhancements for the gun. Anything from 1 year all the way up to life without the possibility of parole. So there's a huge range of enhancements that come with all kinds of different conduct that can be added on. And the problem with enhancements is that they are, by all accounts, the driving force behind mass incarceration in this country. They have never, excessive sentences have never been shown to enhance safety, but they actually have been shown to exacerbate recidivism. And if you have policies that exacerbate recidivism, that means that you're actually ultimately creating more victims of crime. So there's a concern that these policies that are really a product of the 1980s and the 1990s haven't really helped make us safer, but they have got us into this mass incarceration mess, and they're really littered with racial disparities is the other piece of them. Certainly the individuals who are behind bars are predominantly Black and brown, and I forget the numbers, but it's somewhere in the 90% of individuals serving time for enhancements, I believe for 3 strikes in California, are from communities of color. So I can actually follow up with those exact numbers, but the racial disparities are stark. And just to give you sort of a little historical background in terms of how these policies came to pass and sort of what you're seeing in the media today, I think it's really important to look at sort of the origin of sort of tough on crime policies in California. California has led the way on many things, but not all of them have been for good. Frankly, we led the way here in California when it comes to tough on crime, and much of the rest of the country followed. So, in 1980, our prison population in California was about 20,000 people. That's kind of when the tough on crime era began. By about 1990, the prison population was up to 90,000 people. In 1992, I believe it was when Polly Klaas was murdered. You may remember that really horrific crime. And the legislature responded 2 years later in 1994, along with the voters, in passing 3 strikes. So 1990, again, a 90,000 prison population. 94, we passed 3 strikes. By 1999, the prison population in California was up to 160,000 people. So it was a huge increase in terms of the number of people that were incarcerated in this state. And that really came from one case in particular, right? There was one case that the media and our collective consciousness was people were terrified as a result of what happened to Polly Klaas, and the public put a lot of pressure on their legislatures, and as we're seeing frequently around crime and safety issues, there's a lot of fear that is circulated, And that's how the legislature responded. But it's not the first time, and it's not the last time that happened either. In 1972, the California Supreme Court found that the death penalty was unconstitutional. And in 1978, we brought the death penalty back in California, along with life without parole. We figured out a new mechanism that actually met the concerns of the Supreme Court, which brought the death penalty back in California. Both of those, both bringing back the death penalty and the creation of life without parole, were very tied to the case of Charles Manson. Everybody was, again, another case that was very much in the media. A lot of people were terrified, and because the death penalty was off the table, Manson was actually sentenced to, I believe, either 7 or 8 years to life, which was the maximum for the kidnapping, because he actually couldn't have been, I guess his followers were engaged in the murder. He wasn't actually found guilty of the murder, is my recollection at the time. So he was sentenced to, I believe, 7 or 8 years to life. And every time he came up for a parole hearing, the public was terrified that he was going to get out and that he was going to go on and commit some more horrific crimes. And the legislature brought back both the death penalty and life without parole, largely as a result of that horrific case that was really prominent in the media at the time. So back to enhancements. I just wanted to give you that little history, because I think it's important when we look at sort of the evolution of tough on crime in California and how we got to where we are today. So again, enhancements have never, these really long, big, many years of prison sentences have never been shown to actually make our community safer, but they have been shown to exacerbate recidivism when people get out, and that has the implication of creating more victims in the long term. So Mr. Gascon got rid of enhancements in total, and there was some pushback from a lot of folks in the community, and after hearing from them, he enabled enhancements to be filed in cases solely involving the most vulnerable victims. So there was a modification to that policy that was made in response to his conversations with the community. And then I want to briefly, enhancements, also special circumstances enhancements, can lead to something called life without parole, right? Which, as you know, if life without parole means the person's never going to get out no matter what. And special circumstances can also make you eligible for the death penalty. And I'll talk about the death penalty in a second. But I think also one of the things that you've seen a lot in the media recently is around cases involving life without parole, where somebody will be sentenced to still 25, 30, 40 years to life, but we're seeing actually in a number of cases where victims are coming forward and expressing concerns that the individual is going to get out and cause additional harm. And I think it's really important to address some of the misinformation that stems from that. The parole board releases, depending on how you do the math, only about it makes a release. It actually releases somebody in only about 15 to 30% of the cases that it actually hears. It depends. But the individuals that do get out that are lifers, less than 0.5% of them actually commit a new felony offense. So the parole board is extremely adept at gauging risk. And I think if you compare that to prosecutors, you'll see that the parole board is much more capable of gauging future human risk than are prosecutors. When prosecutors send people to prison, when they come out, the recidivism rate, as you probably know, in this state is astronomical. It's between 60 and 70%. So prosecutors are not very good at gauging future human risk. We send people into prison, they come out, they reoffend at very high rates. When the parole board lets people out of prison, they very, very rarely commit new felony crimes. There's about 5,000 people in state prison in California on life without parole. These are people who committed obviously very heinous offenses. And there's a question, obviously, as to whether certain people should ever get out. And certainly that is a discussion that is best had at the parole board. But there's a question as to whether or not the district attorney, and this is how Mr. Gascon articulates his basis, should he, as somebody who knows that he's changed over 20, 30, 40 years, deprive somebody else of the same opportunity for retribution and rehabilitation and to actually have the opportunity to redeem themselves. That doesn't mean that they will get out. Certainly most people don't. But if they engage in rehabilitation and over the time that they're in prison, they rehabilitate themselves. The policy basically makes it so that there's an opportunity for that. Certainly, again, most people who are sentenced to life in prison, I don't know that most people are getting out in the long term. Certainly, very few actually do, and virtually none or very few actually ever reoffend if they do get out. So there's been a lot of fear around sort of people getting out because of this policy of eliminating life without parole, and I think that's very disingenuous. So any questions about that, please let me know. I'm happy to follow up on that further. Other special circumstances lead to the death penalty, and I think, as you all know, he also took the death penalty off the table. The death penalty is broken for so many reasons. It's very racist in its application. The race of the victim largely determines whether or not somebody will actually receive the death penalty in many cases. It's never been shown to be a deterrent, especially in a state with a moratorium. You end up dragging the victims through decades of appeals, robbing them of any finality in those cases. And again, ultimately for a sentence that's never going to be imposed. You're never going to actually, it's very unlikely in California that we're going to see an execution again. It's possible, but it's very unlikely that we're going to ever see another, just because of the shifting winds on this issue, particularly in California. I think it's not very probable that you're going to see one. In fact, since 1978, there's only been 13 executions in California. The last one was in 2006. Given the cost for both litigation and housing, people on death row has been $5 billion over that time. That brings the cost per execution to a whopping $300 million. So it is an extremely expensive, ineffective, draconian practice, which has been eliminated by the rest of the developed world, and that's why he took it off the table. Bail. So I'm gonna go through. There's a lot of issues here. I'm gonna just pick some of the high level ones, and obviously, if there's any questions at the end, I'll be happy to take them. So Mr. Gascon only implemented bail, or took bail off the table for sort of low-level nonviolent offenses for now. Eventually, what will happen is that he will seek instead what's called pretrial detention. The problem with bail is that rich, wealthy people can buy their freedom while poor people languish behind bars. And that actually has massive implications for not only a poor person who is stuck in jail, they may lose their job. It has implications for childcare. It can absolutely result in housing instability and exacerbate homelessness. While somebody who's rich and wealthy can simply cut a check, no matter how dangerous they are. There's a real problem with the bail system in this country, and happy to discuss that more. But just in principle, it's wrong, and money is just not a proxy for risk. We hear a lot of stuff around, oh, well, this person got out because of bail. There's a lot of confusion around how bail works or how pretrial detention works in general. And by the way, I'm not just a media consultant. I am also a former prosecutor. I think, I don't know if Ann mentioned that, or I'm a former DDA or deputy or assistant district attorney in San Francisco. I was doing policy and communications for Mr. Gascon when he was in San Francisco. But I also, not too many media consultants probably know this level of detail about a lot of these policies, but I just wanted to make sure you knew that I wasn't completely just making this stuff up. So pretrial detention, is the process where someone's arrested and, the pendency of the time, whether they're in custody before trial, right? Before they're actually found guilty of a crime. And certainly if it's a low level offense, there's a lot of questions as to whether or not the person, public safety is benefited by keeping that person in custody before they're even found guilty of a crime. Now, if it's a very dangerous offense, that's a different story, obviously. And in order to protect community safety, the person may need to be detained. But the idea in the long term here, and there's a state Supreme Court case that we're waiting for a decision on any day that's going to have some implications for this, is when we completely eliminate money bail, and there will be some more announcements on this in the weeks and months ahead. Instead of saying, Your Honor, this defendant is committed a very serious offense, and the bail schedule has this, for this murder, for murder is $1 million is what the bail schedule. Your Honor, we'd like to depart upwards to $2 million because the defendant has means or otherwise. What we basically say in court is, Your Honor, this individual poses a danger to community safety, and as a result, we're asking for the defendant to be detained pre-trial. period. There's no money. If the defendant poses a risk to the community, it doesn't matter how much money you have, that person, we will seek to hold that person in custody pre-trial, and that's it. If the person does not pose a threat to community safety, and certainly, obviously, it's complex, right? How do you make a decision? And this is the role of the prosecutor, and it's very difficult to gauge future human risk. This is the business that we are in. It is very hard to do. It is complex. There's various tools that we can use. There's problems with algorithms. If you want to talk about that, we can, but there's been a number of different solutions that have been put forward. Bail is one of the more complex sort of issues to reform, just because these decisions have to be made very quickly. People have constitutional rights. That means if they've been arrested and detained, a decision has to be rendered as to whether or not the charges are going to be filed and whether we're going to keep them in custody within 48 hours. So you have to make a decision as to whether or not this person poses a danger pretty quickly. And obviously, with more heinous cases and crimes, that can be pretty clear. But with less dangerous crimes, where there may have been escalation in the behavior, prosecutors have to do a better job of gauging risk. And simply assigning a monetary value does nothing to help protect community safety. It's completely arbitrary and is not actually associated with the risk that the defendant poses to our community. So that's bail. Probably one of the most complicated ones that I'll talk about today. Kids. For those of you who have kids, I don't have it yet. You may have seen my wife running around here a moment ago. We're thinking about it, but I know for a fact that for those of you who have had teenagers, they do dumb things. They don't necessarily gauge the riskiness of their decisions. They have no sense as to the consequences of their actions. And so with sort of the emerging science that shows that young people's brains don't fully develop until they reach their mid-20s, some people even later, late 20s, it really is problematic to hold kids accountable to the same extent that you hold, an adult to, right? So if you charge a kid as an adult and they're going to spend, they're 17 years old, you charge a child as an adult, now they're going to spend their formative years behind bars. What ends up happening almost always is those individuals who are kept in a concrete box as a kid, that actually is associated with the release of harmful hormones and cortisol in the brain, which actually, what we see is that they get out and they actually tend to recidivate at much higher rates than if you keep them in the juvenile system and you treat them as children. Also controversial because people can, in the juvenile system, you are generally only able to be kept in custody until you're 25. However, there is a process by which individuals who continue to pose a danger to public safety can be kept in custody longer if necessary. That being said, I think there are certain, understandably, when a child commits a murder, right? If a 16-year-old commits a murder and kills somebody and takes away somebody else's loved one, it is a difficult discussion to have over whether or not, the 8 years is long enough for the person to, remain in custody. And I think that this is kind of underpins sort of one of the fundamental discussions. And there's understandably different opinions here as to whether our system of justice should be one that's more rehabilitative in nature and that seeks to enhance safety, or whether it should be retributive. And I think that that's a lot of what we're seeing in the media is, people are concerned that the punishment doesn't fit the crime necessarily. And I think the tools that we're implementing and the policies that are being implemented are reflective of a vision for a criminal justice system that's more modern and is more rehabilitative than it is retributive. And to that end, I think one of the things that I would really sort of wanted to sort of close on, well, I can talk about two more things in particular. I don't know how much time I have, Anne, let me know if I'm rambling or otherwise too long here, but
let's just maybe go another couple minutes and then we'll get questions.
Sure.
You can.
Yeah, I'm almost done. Survivors of crime have traditionally not had their needs met. The criminal justice system just does a very bad job of actually supporting survivors of crime. It's something like 1% of all of the money we spend on criminal justice actually goes to victims. And that is a huge problem. And that's for twofold, right? A lot of times victims and victimizers are two sides of the same coin. A lot of people, a lot of folks in the survivor community say that hurt people hurt people. If you experience trauma, and especially if you live in a community that's ravaged by violence and has a lot of it's not a safe neighborhood to be in. You're walking to school and you're subjected to violence yourself, or it's or otherwise. If you're traumatized in that way, your likelihood to turn to violence yourself is much higher. You hear it all the time about the individual who commits the most heinous crime, who was sexually assaulted as a child, right, or otherwise. You may have heard it in a movie or something. And that phenomenon is very real, but it extends much further than just sexual assault. People who are exposed to violence and who themselves experience violence and are normalized in violence is normalized in their communities are much more likely, if that trauma isn't met, if their needs aren't served as survivors, they themselves are much more likely to turn to crime themselves. So, one of the things that you'll see, I'll just give you a little preview, is a very significant undertaking to modernize and expand the services provided to victims to make sure that they're receiving services sooner, that the services provided are more robust. When Mr. Gascon was in San Francisco, he expanded the number of victims served by somewhere between 70 and 80% per year. So way more victims were receiving help. And he brought victims into the community. And that's actually really important because a lot of survivors don't necessarily want to walk into a police station or walk into 211 West Temple Street into the district attorney's office to get help and get support. So making those services more accessible is also really important, and making them available in a place where people are comfortable to go and actually receive that help and those services. Final bit that I'll talk about, and there's so much to talk about in all these issues. I could easily spend hours talking about any one of them, but the resentencing initiative, which is a huge undertaking, which hasn't frankly even really begun yet. We're just beginning to get it off the ground. So when Mr. Gascon took office, and I'll channel what he said. He said that the pursuit of justice is timeless, and that means that he is not comfortable saying that because you were charged today, you're eligible for these modern approaches and these modern sort of sentencing practices. So we are looking back at all the other sentences where it was excessive sentencing that was sought. That doesn't mean that all the it's 20 to 30,000 people that are eligible for consideration. Certainly not all of them are going to get that. But I want to close on a really important statistic. 95% of people who are in CDCR, in the Department of Corrections, are rated low risk. Who have spent 20 years or more in state prison are rated low risk to reoffend by prison officials, right? Prison officials have access to decades of behavioral health reports and documents relating to an individual's journey towards rehabilitation. So 95% of the individuals who have spent 20 years or more in state prison are rated low risk to reoffend by prison officials. You can imagine that that is a huge number of people. And 50% of everyone in state prison is rated low risk to reoffend by prison officials. So half of the people that are in prison today are, rated low risk enough that, they would be considered by the parole board to be a low risk to reoffend were they to get out. So that just gives you a sense as to both in terms of the excessive nature of our prison sentences and how retributive the system has become, as well as just the huge cost waste that, it costs about $81,000 per year per person to house somebody in state prison. So you can imagine the massive taxpayer resources that we're investing in housing people that no longer pose a threat to our community. So with that, I'll kick it back to you, Ann.
Okay, thank you very much, Max. Okay, so I see a hand up. We do have quite a few questions. Tony, do you have a question or?
Yeah, I do have a question.
Okay.
So for Mr. Szabo, of course, as Democrats, we share values. I think most of us are opposed to the death penalty. Most of us are opposed to disparities in our legal system that affect people of color disproportionately. And we don't want to see poverty punished. We'd like to see the bail issue dealt with so that we're not punishing people for being poor. But of course, the most controversial aspect before it's involved the new administration at the DA's office has been the sentencing. And I'd like to hear from you what you think. What was the policy decision? What was the thinking that removing all enhancements was the right way to go?
Thanks for the question. So I think the fundamental basis is, first off, remember how I started to explain that every crime has a spread. A robbery comes with 4, 5, or 6. So I think that the idea is that 6 years in state prison is no picnic. Let's just be very clear. And if you commit a robbery with an aggravating factor, such as a gun, for example, there's the robbery, potentially assault with a firearm you can add as well. So there's additional charges that are available where you can still get a pretty significant prison term. Robbery is a strike. The assault with a firearm, 245A1 is a strike. So there's plenty of other ways to get a pretty significant sentence if you need it. And certainly the spread allows for, if it's a strong arm robbery, meaning that there's no weapon, somebody just, you're walking down the street and you're on your phone and somebody comes by and snatches your phone out of your hand, that's a strong arm robbery, right? There's no gun or anything else that's involved. You could seek the 4 years, right? So because it's the lower term. So the idea is that, first off, in an office as big as Los Angeles, from a management perspective, there's no real ability to provide a more nuanced policy, right? Well, only in these types of circumstances, it's not really necessary, given the ability to already under the penal code to seek fairly significant sentences to begin with. And again, if somebody commits a murder, right, they're still facing 25 to life on top of whatever other behavior is involved there. So they're going to be in prison for a long time before they even get before the parole board. So the question is, if it's a 25 to life term, what is the purpose of having a 60 or 70 year to life term if it's ultimately the parole board that's going to make the decision as to whether or not they can get out or not to begin with? It's excessive, and it doesn't produce safety. It does what enhancements do is they satisfy our sense for retribution and revenge when somebody does something bad. And I think ultimately in a conversation I had with Mr. Gascon, he didn't want, he knows that enhancements drive mass incarceration. And he didn't feel comfortable saying, I like these enhancements, I don't like those. When we know that no enhancements enhance safety, they do enhance racial disparities, they all drive mass incarceration. There was no benefit associated with keeping them on the table, except for potentially a political expediency.
If I could just follow up on that, the point of where the controversy came was that with the initial request to remove all enhancements, that meant that we couldn't prosecute hate crimes. We couldn't prosecute crimes of senior abuse and other crimes of vulnerable victims. So then the district attorney backed off of that and said, okay, well, we will include those, but perhaps not others. One of the other
I would say that on hate crimes, for example, certainly if somebody commits, if there's no other base offense, right, if you assault somebody, right, and it's a hate motivated offense, again, you can seek the high term on the assault, as the hate would be the aggravating fault factor for which you would seek the higher term. There are some hate crimes that there is no assault associated with it, and that is correct, and that's one of the reasons why he opted to make that change. I think that we can all agree, however, that and the other piece of this, which I probably should have mentioned, is length of sentence and punishment has never been shown to be a good deterrent. If you look at just Google deterrence and National Institutes of Justice, deterrence comes from probability of being caught, not from the length of the sentence or the punishment. Nobody walks into a drugstore and says, okay, I have a prior conviction, so I'm going to get an extra 5. I've got the gun. If I keep it in my waistband, it's not going to be an extra 5 for that. It's just not how deterrence works. People don't think about, how their conduct equates directly to years of incarceration. But if there's a cop car sitting out front of the drugstore, no way they're going in there, right? I mean, that is how deterrence works. It's through probability of being caught. So if we're thinking about this through a safety lens and what actually drives safety, it's never going to be, well, I know I'm going to get an extra 3 years because I did this extra thing. So,
well, if I could just
Tony,
one last follow up,
please.
one last follow up on that. Through my position on the resolution chair with the county party, we took a deep dive on this issue because we had a resolution before us on the subject. And what we heard from members of several communities was that right now, many people do not go to jail because of the conditions we're dealing with right now with COVID. And
Sure.
there are no many times there's no bail on a certain level of crime. So the problem that they're seeing is that there are criminals that do understand that process and realize that if their crime is below a certain level, they can commit a crime and they basically get don't even spend any time in jail and don't have any barrier for going back out and committing crimes. So those are some issues that probably would be issues that this is affected by. The one thing I would like to say, though, is I don't believe that we can prosecute hate crimes without the enhancement. And one of the other enhancements that I think that many Democrats would agree with would be the enhancement for the use of a gun. Do you think that removing the enhancement for crimes with the use of a gun makes us less safe or makes us more safe?
So there's still, for example, the use of the gun, right? There's felon in possession of a firearm. That's not an enhancement, that's a crime. Assault with a firearm, that's a crime. So there's still plenty of crimes that can be charged in association with the actual conduct of using a gun, right? Discharge of a firearm, right? I mean, there's plenty of other offenses that can already be charged. The question is, do you need the 10, 20, 25 to life? Do you need, there's the use of enhancements for gun crimes. You also don't even have to be the one who shot the gun to be able to get the enhancements applied to you. So I know that there's never been any science or data that shows that enhancements enhance safety, but there is data that shows that excessive sentencing practices do exacerbate recidivism and create more victims of crime. So I do believe that the available evidence suggests that the practices that we've engaged in have actually exacerbated, created more victims. And I think that that's evidenced by the fact that during the past 8-9 years before George Gascon was the district attorney under the prior administration, who was very much a tough on crime DA, violent crime in LA County went up 25%. We used enhancements left and right at extraordinary rates. The LA County sent more people to prison at higher rates than almost any county per capita, than almost any county in California, and violent crime went up. What does that tell you? I mean, at the same time, Mr. Gascon was sending people to prison at about 1/5 the rate that Jackie Lacey was when he was in San Francisco, and violent crime in San Francisco either was, basically, depending on how you read the numbers, either down 2% or up 2%. So, we have to get away from this fiction that long terms of imprisonment enhances safety. There's so many collateral consequences that are associated with that. Frankly, and let's move away from violent crime for a second. We led the way on tough on crime in California. I think we'd be foolish not to think that our leading the way on homelessness is not directly related. We turned out, we associate or assigned felony consequences to low-level behavior for decades. We churned millions of people out with criminal records who no longer had the ability to find a job or a place to live, which is also associated with higher levels of recidivism, because if you can't find a place to live or can't find employment, you're much more likely to turn to crime, or you're going to end up homeless. And, if you look at what the homeless service providers in Los Angeles say, they have said, and they've said this publicly, the leading indication of future homelessness is involvement in the criminal justice system. And I think that, certainly on low-level offenses, I think we all probably agree, especially given our more progressive leanings with this group. But even with more serious offenses, it doesn't mean that people aren't going to be held accountable. But there's, the enhancements are not the saving grace and have not enhanced safety in Los Angeles. If you just look at the past, they never did. So I think, past performance is the best indication of future performance.
Okay, thank you. So let's move on. And I do want to get Steve also, if you want to respond to some of these, but let me ask another question. And Steve, if you want to respond, please jump in. This one has to do, and there was a few having to do with, in terms of what you talked about, of how we screen police officers about their conduct. I know Steve talked about the police unions, but in terms of their racial bias, just nationwide, not just here in California, and also how to, together with that, of how to reduce gun violence. So maybe Steve and then Max could respond. And Steve, if you have something to say of what Tony was talking about as well.
Well, I generally agree with what Max has said about enhancements and the effects of incarceration. In terms of the unions, I think the police union problem is a national problem, and I think it's a problem in California, especially. If they spent in Long Beach, the police union has supported financially $300,000 each time. Every time the mayor wanted to raise taxes here, the police union has supported the candidacy of the majority of the city councilman in my city, and the police, as a result, are never publicly criticized for the corruption that goes on in the Long Beach Police Department. And to some extent, that occurs in most every city across the state. And we need to find a way to stop the influence of police unions while also allowing them the due process rights of discipline associated with their disciplinary systems, and allowing them reasonable bargaining rights, but to keep them out of financing these massive pensions and covering up behavior. Senate Bill 1421 passed in the state, gave the public the right to police disciplinary records. What happened in my city very soon after the passage of that we discovered in the MOU with the police union, is that the police union convinced the city council to approve notification 5 days in advance of releasing any information provided to the public through SB 1421. The result of that is that it gives them 5 days to bring a lawsuit, or in the case of dishonesty, which they did in the case of my lawsuit, they brought an appeal to their discipline, 5 days discipline for stealing from the city. They brought an appeal to that discipline and stopped the court process because SB 1421 requires that these things be fully resolved. Well, they didn't appeal before I filed a lawsuit. Now they did. And because of COVID, they're saying, we don't know if we'll ever get to that appeal. So that's why I think police unions need to be harnessed.
Max, do you want to comment, or you want me to?
I mean, very briefly, just, a lot of these reforms actually are beneficial to police as well, that, Stephen is talking about, but there's a culture within, I think, and, within policing and police unions, which has really propagated this myth that criminal justice reform is antithetic to the role and safety of police. If you look at jurisdictions with higher or more restrictive use of force standards, those jurisdictions have fewer, injuries to officers as well, fewer officer deaths. And so, at the same time, a lot of police officers didn't get into this business to be social workers. And frankly, they're not adequately trained to be. And, when we talk about reimagining public safety or defund the police, right? A lot of, certainly there's abolitionists out there. I'm not one of them, but I think police are going to be absolutely essential. But for a lot of folks, what that means really is sort of, diverting some resources to other mechanisms. And if you take money from police and get them into the business of or get them out of the business of dealing with individuals experiencing mental health and homelessness calls, right? I mean, I think in San Francisco, I think in some cities, it's like 80% of the calls to police involve individuals with in experiencing some sort of mental health crisis. That's absurd. And the fact that we're having, those are not calls that generally require somebody with a badge and a gun to respond to. And if you put them in that situation when they don't have the training to deal with it, what we're seeing is, something like a third of all police shootings involve somebody in a mental health crisis. It's just not good for police for them to be doing this. And I think police unions, we have to remember that there's a dollars and cents piece to this too, right? They draw political power from more members, more money, more ability to engage in politics. And so if you're talking about defunding or reimagining and taking money away from police and investing in public health services, despite the fact that it's beneficial probably for their members and their members' health and safety, it detracts from the power of the police union. And I think there's a conflict of interest, frankly, there among police unions as there is with their members. And I agree with Stephen completely that police unions have a real problem in a lot of communities. Anyway, bunch of other questions in the chat, but go ahead, Anne, if you want to.
So that I do want to follow up. So the ones that are in the chat have to do somehow with rehabilitation, and also there's the question about restorative justice. So I think that kind of comes in, and you also talked the survivors getting more money, right? So maybe you could speak to, it's kind of all three, but one having to do with
I'll try
rehabilitation and restorative justice.
And there's one other thing that Tony mentioned about sort of committing crimes below a certain level. That's actually not related to a directive that Mr. Gascon passed. That relates to a 2014 ballot initiative, which was Proposition 47, which increased the felony theft threshold in California to keep pace with inflation. So basically, before 2014, if you stole property above $400, that was at a value of above $400, it was a felony. It was one of the lowest in the country, right? States like Texas have, I think, like a theft threshold of like $1,500 or $2,000. This is not like a liberal or conservative state thing. We just had a really low theft threshold. We hadn't increased it. Some people have tried to say that people are, making decisions about, well, if I get $940 worth of property instead of $951, I'm going to get a misdemeanor instead of a felony, and I'm going to get cited and released. Putting aside the ridiculousness of somebody, sitting there with their calculator trying to figure out how much property they stole, since Proposition 47 passed, and we're seeing this with some of the city councils and some of their language around some of these. They clearly don't know what they're talking about. The Beverly Hills mayor actually said that this was one of his directives, but this was a voter initiative from 2014 that was passed with 60% of the vote. And since it passed, statewide property crime in California is down. Racial disparities are down. Recidivism is down. These are all published numbers. You can go to the DOJ's website and just go through the Open Justice portal and see that property crime statewide is down. Certainly, if you have property crime spikes in certain communities, when that's not being, exhibited on a statewide level, you probably got to look at what's going on in that community and what that city is doing around certain public safety strategies. How are the police working? How are they going after repeat offenders, et cetera? As opposed to this statewide initiative is causing this or otherwise. So I just wanted to address that. So quickly on sort of restorative justice. really, really powerful. Survivors, you would be really surprised, and I know that we see a lot of victims out there on TV, expressing their concerns and outrage, and there are survivors that feel that way. And the survivors that I speak with a lot of victims. If you take a mic and you stick it in someone's face at their most traumatic moment in their life, at a sentencing, at a parole hearing, or otherwise, yeah, they may want the most, the maximum penalty. I get that. If it was my family member, I might too. But if you talk to victims that have kind of gone on their journey to survivor, that are, have learned to live with the victimization that they've experienced, very often, and most often actually, they tend to have a very different opinion as to what the criminal justice system should do. And frankly, a lot of the times, they want, actually, there was a poll that came out last week or 2 weeks ago of crime survivors and violent crime survivors in Los Angeles County. It showed that the vast majority favored rehabilitation rather than more incarceration. So I think it's really a myth that most victims want the maximum penalty imposed in these cases. There are those victims, and they will, and their voices are absolutely equally valid. But if you look at the research that's out there, that's not reflective of the majority of the survivor community. And I think that's really important to keep in mind. In terms of victim offender mediation, survivors tend to, really get closure out of that. Very few survivors, and first off, there really is no closure. I should not say that. If you lose somebody or you're a victim of a traumatic violent crime, it's not going. There's always going to be that void. You're always going to have had that experience. And you're going to have the trauma that's associated with it. But most people tend to get a lot out of a victim offender mediation. Some people want nothing to do with it as well. It can be a really powerful healing opportunity for the survivor and for the offender, frankly, to take accountability for what they did. So it works really well. Definitely, restorative justice. He hasn't rolled out the same practice here in Los Angeles yet. It's a program that he's working to implement. There's something called Make It Right, which is a program that Mr. Gascon pioneered in San Francisco. He basically, I forget what the numbers were, but I mean, I think only like 12% compared to, there's a huge reduction in the number of people of juveniles who reoffended, who participated in this fully restorative justice process, where the youth offender would actually meet with the victim and they would have a conversation. And the kids that went through that process, as opposed to the traditional juvenile process, reoffended at like like 75% less often, is what I recall the number being. I mean, so it's great for the victims. Generally, they tend to get something out of it, and it really works well for the offender as well. So I think it's, as much as it's possible, you have to be really thoughtful about whether the survivor wants to engage and wants to be a part of that process. But I think it is absolutely something that the district attorney is going to be looking to do more of. There's a question in here about why the DAs are fighting these initiatives, and also about overcharging as well. So just deputy DAs have, it's kind of a self-preservation thing, but also for a long time, the way that you would advance is based on, your convictions, the number of years you got, right? I mean, the more, the more years you were getting, the more convictions you were getting, that was the barometer of success, as opposed to, did this person come back and reoffend again in the future, right? And so I think, part of what this is changing the metric of success to, what's going to be the best long-term outcome for the survivor, for the victim in this case, for the community, right? Are we going to spend, $80,000 a year to put this person in a concrete box when they're going to get out in, 6-7 years and reoffend, turn around and commit another crime? Or and for the defendant too, right? To make sure that they can rehabilitate themselves and turn their lives around and re-enter society. So the other problem is deputy DAs are terrified of something happening, right? If I don't seek the maximum and the person gets out and hurts somebody, it's on me, right? I didn't, I want to be able to say that, I got the maximum sentence so that they can't blame me if anything goes wrong. And that thinking is just backwards, because seeking, again, seeking those excessive sentences has actually led to more victims of crime. It increases recidivism. So we have to be cognizant of that. But I think that that's a cultural issue. Just plain and simple is, most DAs are exposed to a culture wherein they are, trained to seek the maximum sentence, and kind of moving them in a different direction and exposing them to a different approach. It takes time. It's gonna take a long time. I'm not gonna shortchange that. I will tell you, Mr. Gascon was the DA in San Francisco for 9 years. Not everybody, but there was a major culture shift among the line deputies in that office. There's always going to be people who are not going to be able to be broken of that mindset and that approach. And, I think prosecutors, police as well, we're all kind of traumatized by the things that we see and that we're exposed to. And that can have, impacts in terms of how you view this work and your approach. But I think it's a cultural issue, and we have to do a lot of education, in the office and to basically, reform that institution in that way as well. And then legal issues based on sorry, I'm looking through here. And which are the ones that I miss here?
Actually, I think you got most of them. I wanted to just segue a little bit. So when we talked about holding law enforcement officers accountable for their serious misconduct, this kind of segues into, I just want to mention that Senator Stephen Bradford from Gardenia and Senate President Pro Tem Tony Atkins from San Diego introduced Senate Bill 2 in December, and it since has gone to committee to hold law enforcement officers that commit serious misconduct and illegally violate a person's civil rights accountable by creating a statewide decertification process. And so it turns out California is only one of 5 states in the nation that does not have this authority to decertify law enforcement officers. And so that's what this Senate bill is going to do. And I just wanted to bring it up because it talks about this accountability that both you and Max and Steve have been talking about. And this has to do with a case that happened in Gardenia back in April of 2018, where Kenneth Ross was killed by a policeman and got off. So I just wanted to bring that up. The other one has to do with enhancements, and this is a bill that Senator Ben Allen introduced, Senate Bill 483. And so there was a bill that was removing sentence enhancements, like starting from now. And I don't know if Natasha is on. She was supposed to be on. Anyway,
yes, I'm here. Ann.
Oh, okay. Anyway, so Senator Allen couldn't make it, but this has to do with removing those sentence enhancements retroactively. And I just, we don't have a lot of time, but I just wanted to mention that was introduced just in mid-February. And Natasha, I don't know what the update of that has been.
I'll just give you a real quick summary. So this is a bill that is based on a recommendation from the California Committee on Revision of the Penal Code. The issue here is that the California legislature repealed 2 sentencing enhancements that the legislature determined were particularly unfair and applied in a racially biased manner. But the repeal of those sentencing enhancements was applied prospectively only. That means we have people in prison and in jail right now serving time under these enhancements, what we have come to call zombie enhancements, because these enhancements are dead, but not for the people who are actually serving time under them. So SB 483 will correct this injustice, and it will legally repeal the enhancements going backwards so that we don't have people continuing to serve lengthy sentences in jail or prison based on enhancements that the legislature has determined are unfair and unjust. So there'll be lots of opportunities to support this bill as it moves through the process, and happy to answer any questions.
Okay, I just wanted to make sure because those were the two items that both Steve and Max were talking about, and there is legislation that's going. And before I get with Tony Hale was going to talk about what the LACDP has been doing. A number of people have also, you've kind of talked to, but George Gascon, he's facing the same thing as Newsom in terms of a recall talk. I don't know if Newsom's will go through, but anyway, so do you have any, both Max or Steve, any comments on that or what he's facing? And I just do also want to mention in San Francisco, we have a progressive DA. I'm not sure if I'm saying her name right, Chesa Bodine. So she's been there. She was elected in 2019. And I'm assuming she's able to continue fine, but I don't know if she's facing the same wrath as George Gascon. So Max or Steve?
Stephen was, I think, trying to say Chase is a he, FYI.
Yeah, he, right?
Yeah, he.
Yeah.
Oh, it's a he. Okay, I'm sorry.
I think so,
I am
yeah.
so sorry.
Yeah.
Yeah,
Well,
look, go ahead, Stephen, sorry.
No, I just say that the list is growing of the progressive district attorneys across the nation, and the individual that took George's place in San Francisco is among them. And of course, George began in San Francisco 9 years ago, and we're seeing a lot of very hopeful movement in terms of how criminal justice is going to work across the nation. And these progressive district attorneys, this movement just really needs to be supported. And as it's supported and as it becomes stronger, I think you are also going to see better professionalism in our police departments emerge. As I said at the beginning, I don't consider the relation between police and prosecutor as a partnership. It's a check and balance relationship that should be cooperative, but it should be aimed at achieving justice, not a conviction. And we all know, judges especially know, that officers lie on the stand and prosecutors permit that lying to occur because it helps them get that conviction. And I think that this progressive movement among prosecutors is going to change that significantly.
So I would just, in terms of the recall efforts, I think obviously Governor Newsom is in a different situation than DAs Boudin and Gascon, in so much as the state of California has, I would say, sorry, I'll say it this way instead. Los Angeles and San Francisco are very progressive communities, whereas the state of California, as progressive as it is, obviously not as progressive as LA or San Francisco. I think that there will be difficulty encountered, especially in a pandemic, and collecting the requisite signatures to get a recall on the ballot. I think it's going to be expensive. In San Francisco right now, it's about $12 per signature. So if you want to do the math on how much that's going to cost to get it on the ballot, it's going to be pretty tough. And I think another important piece of this is, look, they're just bottom line, they are all led by Republicans, right? All three of these are led by conservative factions, even among the Republican Party. In Los Angeles, Dennis Zine is the chairman of the recall effort, and everybody on it's not really a victim-led effort. It's a Republican-led effort. There's maybe a survivor or two that's on the actual, that's on the governing body of the recall committee. But by my count, I don't see any Democrats on the recall committee. It is led exclusively by Republicans. And in San Francisco, I don't know as much about it, but I do know that the person who filed the paperwork for the recall petition is also a Republican who actually ran for mayor as a Republican in San Francisco. You can imagine he did not fare too well.
You should also know that Dennis Zine is a former Los Angeles police officer and a former board member of the police union in Los Angeles. I don't have the number, maybe you do, Max. How much money has the police unions and the district attorney unions put to this recall effort? And it'll give you a good idea why it's the status quo that wants to keep things as they are. Yeah, status quo.
The money, you know, the disclosures haven't been made public yet in terms of how much money they've raised for the recall. I don't know. I actually think that the ALADS is more likely to be in the mix on some sort of funding any sort of recall effort in Los Angeles. So that's the sheriff's union as opposed to LAPPL, which represents police officers for the LAPD. But you know, if it's any indication in the election, you know, police unions spent somewhere in the ballpark of $5 to $6 million to defeat Mr. Gascon. It was the most expensive district attorney's race by all accounts in history.
Okay. I was going to ask Tony to talk in here, but I think I see him on the phone. So he had wanted to talk about the resolution.
Hi, sorry about that. I did get a call just before that, but I can talk now.
Okay. Okay.
All right.
So you had resolutions that you guys have been working.
Well, when I saw the topic of this subject, like I said before, we did do a deep dive on this issue, and we spoke to deputy district attorneys. We spoke with representatives from the DA's office, and we spoke to victims. And we felt that it was a very complicated issue. It was hard to dissect the difference between enhancements, because initially the DA's office, the new district attorney, proposed removing all enhancements. But then again, it would seem very clear from the people that testified before us that would remove the ability to prosecute hate crimes and other crimes that do not exist without an enhancement. So some of the arguments that have been used to justify the arguments for removing all enhancements have conflated situations that I think are confusing to the average Democrat, and that is that the three strikes law has changed over time. It's been reformed, and so it's not the same three strikes law as before. A lot of the mass incarceration that came after the drug war and the Reagan era led to excessive incarceration. That's another factor. It was hard for us to get any credible evidence that enhancements were leading to the disparity of racial disparity in the sentencing. So the party took a stance and passed a resolution that called for limiting enhancements to where they affect this disparity and lead to mass incarceration. And so I'd be very interested in getting any kind of studies or statistics from Szabo about how some of the statements he's made about how these enhancements don't make communities safer and how they lead to recidivism. But again, there's many moving parts in the justice system, and the way that the law is enforced is, you know, the arrests and the way victims are treated has very little to do with the sentencing. Anyway, it turned out to be a very complex issue that we struck a middle ground on to try and figure out, as Democrats, what it is that we believe in. One of the other factors that came up today was about the difference in the crime rates. LA County is probably one of the top gang capitals of the country. We have a lot more crimes related to gang and violent crime than exist in San Francisco. They're not quite fair comparisons, and statistics are always difficult to appreciate, but since December, violent crime and homicides have gone up in LA County. So it's hard to measure exactly what is having an effect. and where it's having an effect. As Democrats, we all agree that we want to make our justice system fair. We want to make our justice system anti-racist, and we want to not punish people for being poor. And I don't have much more to say about that. I did want, if Natasha's still in the line, I would like to hear from her exactly what new enhancements that the senator's bill was removing. And for Mr. Downing, obviously one of the problems we have with law enforcement is what I would call a culture. And I'd like to hear from him as a former law enforcement officer. What can we do to change the culture? Because if we change that culture, I think that we would change the nature of their employee associations, and we would change the way that people who are arrested are treated. And
Ann, do you want me to take that?
You want me to do the culture now, or
Sorry, Ann, you're on mute.
go ahead?
I'm sorry, I muted myself. So what I'd like you to do is, for the sake of time, is we use this time to answer Tony's question, but also if you have any closing remarks. So we'll start with you, Natasha, in terms of showing detail about what Alan's bill is, but also Max and Steve, if you could answer and also have some closing remarks. Thank you.
Yes, so the two enhancements that were previously repealed by the legislature that SB 43 applies to, one is previously there was 3 years added to someone's sentence if they had a prior drug conviction and got a new conviction related to drugs, which it enormously impacted Black and Latino young men. And then the second enhancement was one that added 1 year to your sentence if you had previously been sentenced to jail or prison. This resulted in enormous disparities because it wasn't based on the facts of the crime, but what you had been sentenced to before. And of course, what you were sentenced to before is impacted by racial bias throughout the system. I also put in the chat the California Committee on Revision of the Penal Code report, which did a very deep dive into sentencing enhancements, found no evidence that any sentencing enhancements actually improve public safety, and strongly recommends additional reforms to scale back the use of all enhancements. Thanks for having me.
Thank you.
As to changing the culture, that's probably the toughest thing to do, and it's always long-term. But my son followed me after I retired. He joined the police department, and he retired a couple of years ago as a deputy chief. And he told me that perhaps the most significant thing to contribute towards a change of culture in the Los Angeles Police Department was the existence of the consent decree. It went on for several years. Bratton came in as an outside chief, which is important. Bratton was allowed to bring in outside consultants who looked at critical areas of the department, such as training, recruitment, intelligence functions, informant management, all of those kinds of things that have the potential to produce unprofessional policing. And so I think that he made strides, and those strides were allowed. First, I believe, during my time, Chief Ed Davis was the first chief to really introduce strong code of ethics and mission statements and put them into meaningful training programs. So Bratton had the advantage of that existing. Bratton had the advantage of community policing, a structured community policing already in place in Los Angeles. And so with those two things going for him, and the implementation of the consent decree and the hiring of a constitutional attorney as a personal advisor to oversee and manage that consent decree, I think and my son believes in it dearly, that this was a real cultural change for the LAPD. Smaller departments don't experience that. Smaller departments are controlled by city councils that are elected by the unions. And smaller departments like Long Beach, which desperately needs a new culture and to get rid of the cronyism and the cover-ups and the white supremacists that are allowed to remain, and a disciplinary system that is effective, an internal investigation system that is effective. They need cultural change. They need outside chiefs. They need inside those chiefs to bring in consultants, and they desperately need consent decrees. But unfortunately, the DOJ hasn't brought consent decrees against these smaller departments unless there's this great outrage. So I think those are the best approaches for changing cultures at this time.
Max?
Yeah, I mean, I think I'll close by just saying that, you know, there was really no data or science that ever supported the creation of the policies of mass incarceration, right? There was no science or data that said this is going to enhance our safety. These were policies that were responses to, you know, fear. And, you know, we can't be a modern society and just shoot from the hip when it comes to policy making that affects not only safety, but certainly racial disparities in the system, huge implications for taxpayer resources and more. And so, you know, what I think you're going to continue to see in Los Angeles is, you know, the implementation of policies that are driven by science and data. And that certainly is, you know, has and will continue to draw controversy because it's a big change from where we've been. But I think it's really important to ensure a better future and, you know, to make sure that, you know, Los Angeles has a criminal justice system that everyone can be proud of.
Thank you very much. I've learned a lot. I hope our audience has learned a lot. One of the quotes that I wrote down from Stephen was, let's stop kissing the ring of the status quo. And hopefully we can all reimagine our criminal justice system and support what George Gascon is doing. Thank you very much. We're going to move on to any last minute things that some of the members might want to talk about, but this concludes our discussion. We did go a little bit over time, but you guys were great, and thank you just for taking the time on a beautiful Sunday afternoon.
Welcome.
Take care.
Bye-bye.
Bye-bye.
Yeah, I just wanted to say we have a terrific restorative justice program in LA. It's been going for like 28 years, and it uses volunteers without any training, and they train them to be mediators, and they do mediations between youth offenders and victims, and very popular with victims, very popular, very effective on reducing recidivism. And you can look them up under cys-la.org, based in Hawthorne and Inglewood, but they serve all of LA County. Award-winning on the National Evidence-Based Registry of Evidence-Based Programs, etc. So the DA has a good foundation to build on.
Thank you so much for that information, Steve. Anybody else want to add anything at the last minute? Okay. I know some people said at the very beginning that if they had information about getting the vaccine, you might want to say it at this time, but other than that, it was great information today, and thank you for all coming.
Yeah, there's a phone number, 213, that if you call them, they will get you an appointment. Let me find that piece of paper. Shoot.
Well, he gave us the website. Yeah.
Oh, yeah, 213-986-7604. And they have a live person, and they'll work on the internet and find it for you.
Okay, thank you so much.
Yeah.